83. Fifth, there was nothing in the risk assessment report of Miss Prince which could comprise an assessment result of relevance to terrorism behaviour. We know, before we read through this again, that Miss Prince is a failed quack, employed by the state, used by the state like a puppet to provide an outcome that the state desired, rather than standing on her own laurels and presenting her matters within her own framework. 113. The notable difficulties in determining the specifics of Mr. Kiskainen's risk are further complicated by the limitations of the assessment having not been afforded the opportunity to involve Mr. Kiskainen in interview or assessment. Further, whilst the United Kingdom of Australia promotes and adopts the sovereign citizen style beliefs, their overt promotion for violence to achieve sovereignty is not clear. To the knowledge of the author, the United Kingdom of Australia has not been designated as a terrorist organisation. As such, whilst it is evident that Mr. Kiskainen has previously taken a leadership role in the group, whether his behaviour could constitute a serious terrorism offence is directly related to the fundamental intent of the broader group. If the United Kingdom of Australia was designated as a terrorist organisation, he would certainly present a threat regarding. So, knowing that there is no threat, knowing that there is no crime being committed, making an assumption that this is a sovereign citizen style belief, and then still going ahead with trying to fit that into a terrorist organisation box, directing the activities of a terrorist organisation, section 102.2. Well, he fits into this box, membership of a terrorist organisation, section 102.3. Recruiting for a terrorist organisation, section 102.4. Training involving a terrorist organisation, section 102.5. Getting funds to, for, or for a terrorist organisation, section 102.6. Providing support to a terrorist organisation, section 102.7. 114. There is currently no information that suggests that Mr. Kiskainen is or had previously made any preparation towards undertaking or directing others to undertake any act of violent extremism, politically motivated violence, or terrorism activity. However, I found a way to get this report justified for the police. However, his statements and promotion of the government officials as war criminals, foreign occupiers, and Australia currently being an occupied country, and therefore rules of war applying, are certainly significant expressions of concern. Concern to who? Those of you committing those international criminal offences under your own rules. This is furthered by his making statements regarding holding the police, courts, government to account, using them as an example through military jurisdiction, military trials, and noting that some public servants deserve to be hanged and their necks snapped. He notes it would bring him pleasure, no, satisfaction. His role as the face of the kingdom has him creating and promoting written documents, recruiting and encouraging others to take the oath, promoting the ideology and the imminence of needing to pick a side in order to be afforded protection. Whilst he is not overtly or publicly calling for violence to overthrow the government, he does create and sick environment and a narrative which would easily be interpreted as a call to arms, at which the judge then, if we were to go forward again, would then talk about a curial overthrow of the government, and not amounting to a terrorist act, and therefore being a rightful way for a call to arms to occur. It can't be deemed a terrorist act because it's excluded from certain activities in the definition. So this slide here is defining lawfully a standing at which the justice says very clearly what the defendant is advocating is for the people to assert their rights. But if you are forced to, leave peacefully and keep a diary of what happened. Those are justice's words. Okay, so for a people to assert their rights, assert, right, stand up for, present them, not back down from them. That's a standing. You don't need to go running into a war. You don't need to go running around like children. You don't need to go running into the police. But you sure as hell can stand up and stand up to them. You don't even have to raise a fist to these people. All you have to do is stand up to them. And eventually that might mean filing every single fine you ever get from these people into the courtroom. Keep a diary of the interaction, because they become a foreign crown on your soil, technically within the realms of these courtrooms. And the justice is hinting at this very, very strongly, using the term curial, a curial overthrow. This is King's Court. And this is where no one's calling for an overthrow of government. That is a strong term to throw around. We understand that violence leads to a nanny state using its rules against us, giving the police an excuse to react, and getting a reaction is what they want. So the advocating not to go in violence detracts or takes away from the police the ability to react